Good evening. I'm Jay Johnson at JL Johnson on Twitter. I'm here with my wife, Ashley. Ashley is at Tooth Criminal on Twitter. We're here tonight talking about the Holly Bobo trial that's currently going on in Hardin County, Tennessee, in Savannah. I know there's been a big following of the case online, on the news media, on social media. Not that we have any great insight beyond what anybody else would, but we are relatively local. And we just like to throw our 2 cents in. So by way of introduction, I'll let Ashley introduce herself and give you a little bit about herself and her background and why she's both interested and has some insight into the case that you might be listening to, willing to listen to.
Well, I have a bachelor's degree in criminal justice, but I also have a degree in dental hygiene and licensed dental hygiene. And throughout my criminal justice education, I've always had an interest in forensics. When I decided to go into the dental field, it was kind of a nice intersection where I got into forensic dentistry. It's just as a point of interest. I don't practice in it in any way, but it's just a point of interest. And since there was a forensic dentistry element to this case, that's kind of one of the big things that drew me in, and above and beyond the fact that it happened in our local area. And so that's really kind of the main focus for me.
Okay. I'm a lawyer in Henderson, Tennessee. I have a solo practice here in Henderson, Tennessee. I've been practicing law in Tennessee and all parts of the state, from west to east and middle, for the last 18 years. I'm primarily a civil litigation attorney. I do some other things in addition to that. I'm not a criminal defense attorney, not a prosecutor, never have been. But I have been a trial attorney for a lot of years, so I know a fair bit about the court process, and I do have an interest in that process. And so that's where I'm coming from a perspective of offering any kind of thoughts about the case and the trial tactics and the procedures and the process that have been followed as the case has moved along. Both of us have been pretty active on Twitter talking about the case, giving our kind of real-time thoughts about the way the case is being presented and things where things maybe could have been done better, things that were positive, things that were negative on both sides of the case as it's been presented. So I thought we would talk tonight just a little bit about initially kind of some of the initial thoughts about the presentation of the case and the way it came across to the court and through the jury, and go through some of those factors in the case. Obviously, the state's presenting a case for a case of kidnapping, murder, and rape of Holly Bobo as against the current defendant, who's Zach Adams.
Now, I'll say one pause. You're kind of coming at the perspective of much more the attorney perspective.
Sure.
You're coming from the counsel table. You're viewing this through that prism.
Sure.
I would say that I'm probably viewing this as an additional juror. I'm not an attorney, and I know enough about things because I've lived with him for a good long time, but I'm not I'm not an attorney, so that part doesn't necessarily always read to me. I'm really coming at this as like an additional juror.
Sure.
I'm viewing this through the prism of someone who's sitting inside that jury box.
Sure. And my perspective on the case, obviously, I'm coming at it as a lawyer and as an advocate for clients in court, where I'm looking at both just from a sheer procedural process of the way the case is being handled from the attorney's perspective, as far as how they're putting the evidence in the case, how maybe the court's ruling on evidentiary objections, and certain parts of their timeline and the story of the court, the parties are trying to tell the court and trying to explain to the jury. So more about it from that perspective. Again, I don't think either one of us we never prejudged the case coming into it. I don't know enough of the facts of the case. The only real parts of the case that I know are dribs and drabs that have come in through the news media over the last 6 years since the abduction took place, and what's actually been presented in court. Everything else is kind of speculation and things of that sort that makes it really hard to make an accurate assessment of the way the case is going to be presented and ultimately handed off to the jury. So, so obviously, from a procedural standpoint, the state's case is first. The state's the one presenting the case to the jury about why this particular defendant, Zach Adams, is criminally responsible for the abduction, kidnapping of Holly Bobo on April 13, 2011, and why he was involved in her rape and why he was associated with her murder. So there are a number of things with regard to the state's case that have obviously been brought up. The case is significantly circumstantial from a standpoint of there not being a lot of direct evidence in the case, and that goes most of the quote-unquote direct evidence as far as her death goes back to some of the forensic things that were found when they finally discovered her body about 3 years after the fact. And so what talk about the things that they found. What did they actually find on the scene of the recovery of her remains?
Well, as I understand it, they found fully her remains were fully skeletonized, which meant that all of the soft tissue that might have given some indication as to her manner of death was gone. Her body was fully decomposed, so the only thing that was left was her skeleton. And even of what was found of her skeleton was very minimal. They found her skull, which was essential in making the identification, and that goes back to the forensic dentistry, because they actually that's the way they made her identification, was through dental records. They found portions of rib. I know they found several ribs. I don't think they found any of the long bones as far as the legs or anything like that. And, that's to be expected when a body has been left in, in outdoor climate for an extended period of time. You have animals that are scavengers, and a decomposing body attracts that. And so there's, her remains could, there were suggestions in the closing arguments, not to get too far ahead, that there were, things that happened to her as far as possible dismemberment or whatever, but we
Sure.
don't know that, because all that was found were her skull and some ribs and some other small bones. And
teeth,
lots of teeth. Not only the teeth that were remaining in the skull, but there were teeth that were scattered about the area. And that actually speaks to the gunshot wound.
Certainly.
Because of the fact that the pathologist testified to the fact that the gunshot wound was administered to the back of her head, and the bullet would have exited through the front of her skull. And so that would have probably forced out a good portion of her front teeth. And based on the pictures that I saw on the trial footage, the majority of the teeth that they recovered that were loose in and about the area looked like front teeth, anterior teeth. And so, that, not to go too far down that.
Sure. There are a number of lines in this case, and this being one of them, where there are holes on both sides of the proof. Certainly from a legal perspective, I think everybody recognizes that the burden of proof is on the state to prove the case beyond a reasonable doubt, and that's a pretty high standard. It's as high as we really go in the American judicial system. That proof of beyond a reasonable doubt has to show that basically there's no other plausible kind of alternative way that this story could have happened, but for the way that they're saying it did. With the way the investigation was handled, there are significant limitations on the state's ability to prove that. And I think that goes to the way the case was presented by the state on their presentation of the state's case. The vast majority of the state's proof, they initially went through bringing the parents of the family, Dana Bobo, her father, and Karen Bobo, her mother, and Clint Bobo, her brother, in originally at the very beginning of the trial presentation. And obviously those things are going to appeal to the emotional aspect and kind of starting up that part of the jury to feel the sympathy and the loss that those people have felt from losing their daughter in this just heinous and tragic way. And it's not necessarily a bad approach, and it's probably the correct approach from a standpoint of presenting this case, where it's entirely circumstantial. There's very little direct evidence. Lack of DNA, lack of real proof that really clearly links, physical evidence that clearly links Zach Adams and any of his alleged co-conspirators in this event to this crime. So you go through that initial phase, and then you start talking with some of the initial investigators from the local sheriff's department, the Tennessee Bureau of Investigation, the other law enforcement agencies that were attached and associated with the search and the initial looking in the case. And you go through that through the first few days of the trial. And what it really does is start setting up a timeline in the case where, frankly, they look kind of inept, and just that's the overall assessment of it. And some of the later law enforcement testimony looks that way as well. The investigation was handled. It looks kind of just kind of slapped together in a way where we're just trying to find Holly, and I think that's certainly that part of it's appropriate. I mean, you got a missing person allegedly abducted. One of probably the initial theories that they come up with is somebody abducted her for purposes of sexually assaulting her or raping her. That's a reasonable assumption to make in that kind of situation. She's a young, attractive, beautiful girl.
And obviously there's there are the timelines that go into missing persons where, if once you get past a certain time point, I think a lot of it's often like 72 hours that, the odds of finding that person become more and more diminished. And so I think, yes, the initial focus was on, let's find her. If she's alive, let's find her. And, and also the other thing you have to point out is that this, Decatur County is a small rural county in Tennessee. This kind of crime is not the kind of thing that happens all the time. When a sheriff's deputy or a police officer in a small town or county like this rolls up on a situation, they are probably not prepared for a crime of this magnitude.
Sure.
And so, to give them a little bit of grace, they probably were not expecting to get into the depth of a crime that they ended up getting into.
Sure, and there's a sense of urgency and a sense of kind of that immediate action. We've got to do stuff, and we've got to do it right now. That kind of leads to some of that frenetic kind of initial searching and things, and it was fruitless, obviously, at that point. They didn't find Holly. They didn't find the perpetrators of the crime, perpetrator or perpetrators of the crime at the time, and then many years go by in the interim. So the state, in presenting that proof, is, I think, just trying to show that they were trying, they were working, they were doing as best they could with what they had to work with, which wasn't a lot. It was really just Clint Bobo's statement of he heard some commotion out in the backyard and saw some guy in camouflage walking off with his sister. The case really, though, from the state's perspective, I think is abundantly clear from presentation of the trial testimony. Their case rests entirely on the testimony of Jason Autry. Jason Autry, one of the co-conspirators in the incident, according to the state, who was involved, according to Jason Autry, only in the aftermath of the abduction, the alleged rape, and then the subsequent murder of Holly Bobo.
Well, but no, he he was very adamant about his not participating in the sexual assault or the rape of her.
Absolutely.
You know, I mean, and that, I mean, I'm not speaking to the truthfulness of his statement, but when you have, you know, it's kind of common when you have people confessing and when you have co-conspirators that are providing testimony against other co-conspirators, it is, it's not uncommon for the person who's providing the testimony to minimize their involvement, you know, because one, you know, they want that, you know, they're not going to stand up and say, hey, I was the ringleader. I was, you know, I was running all of this. This was all my idea. You know, they're going to definitely minimize their involvement. Now, I'm not speaking to the truthfulness of his statement with regard to his participation in the kidnap or the rape or the murder or whatever, but you know, he was very adamant on the stand about not participating in the rape, and he very much, you know, and talking about the minimization, he very much wanted to bring it to. I just rolled up on this.
Yeah,
I didn't want to be a part of this. You know, I just want to get high, man, and then I get roped into this whole thing, and so
that's true, and I think that goes to what you're saying about him minimizing his involvement in it, and again trying to look at it from a standpoint of coming into court. There's not a written immunity agreement with the state with Jason Autry. He's still indicted as a co-conspirator in this crime. Could theoretically be put on trial tomorrow for the same events, same charges, same potential death penalty sought. I think the assumption that is fair for everyone to make is that the reason he's coming into court that way is that there's some at least tacit or unwritten agreement that says that, yeah, if you come in and testify, we're not going to prosecute you, at least not in that way. Maybe some significantly lower charge, some facilitation after the fact kind of charge that relates to the aftermath of that event. The thing about Jason Autry's testimony from a perspective of a lawyer presenting it, he was testifying, I believe it was day 4 of the trial. There obviously been that lead up that we talked about a little bit earlier about the initial part of the trial. Autry was on the stand pretty much the entire day, I think on day 4 of the trial, both on direct from the state and cross from the defense. I think I tweeted it back at the time, is that the thing about Jason Autry, he is a reprehensible human being as far as his history, the things that he's done, the crimes he's committed, his connections, which he admitted on the stand, being a member of the Aryan Brotherhood, which again, it kind of goes back to the overall theory of him being and minimizing his testimony from a standpoint of credibility and the self-servingness of his testimony, which is something I think the defense should have done maybe a little more work on, in showing that you're telling this story because you think it's the most likely story you can tell to get you out of the most trouble that you could possibly be in. His story, when I was tweeting about it, when I was listening to it, it's like his story that he's telling is entirely believable. I mean, he's giving an account of events that could have readily happened that day. It's certainly the version of the story that the state is trying to prove as their case as to why Zach Adams is criminally responsible in this case. It is believable as a narrative. It is a potentially plausible version of the facts that led to Holly's death. It is likewise that even though his story is believable, taking Jason Autry as a person sitting on the stand, he's an entirely unbelievable person. I mean, he has no basis, no reason why we should credit his testimony as being truthful or honest or having anything other than self-serving motives. So from a standpoint of presentation of the case, I'm curious to see ultimately when the jury comes back with this verdict. I think if the jury does wind up convicting Zach Adams in these cases and these charges, that I think they're going to have placed a lot of value on what Jason Autry said about the events and believing him. And if that's the case, then the jury will have seen that testimony is believable and truthful and honest for whatever reason. I mean, I think that's where the state kind of hangs most of their case.
Well, I mean, yeah, he is. I mean, he is the crux of their case because, I mean, he's the one who creates the timeline.
Sure.
He's the one who creates the sequence of events that sets up her abduction, her rape, and her ultimate murder, and the disposal of her body. And because, I mean, without him laying laying that storyline out, you really, I mean, you don't have a lot of like actual hard forensic evidence that lets the investigators put a real timeline together.
Sure. And I think the timeline is really kind of the problem, one of the big problems with the state's case. I mean, they're really relying on Jason Autry's testimony to establish what kind of timeline they have. Basically, the only timeline they have is kind of a starting point from the time Holly is abducted. That's really the only starting point that morning there, just before 8 a.m. on that morning, when Clint's reporting that he hears the noise and the sounds and sees Holly going off in the woods with the guy in camo. Beyond that point from a timeline, everything else is pretty. Got some cell phone pings, and there's tons of testimony throughout the course of both the state's case and the defense case related to the cell phone pings, which is potentially believable, if depending on which version of those you believe, whether you believe the state's case on that with Special Agent Frizzell, who is their cell phone expert, or if you believe the defense expert that calls that into a little bit of question. I believe John Reeve, I believe that fellow's name. But the problem you keep going through with the state's case, the state has some stronger witnesses from the TBI who come in, testify about some things that are relevant. They have pathologists come in. They have the investigator who came in to testify about the recovery from the site by the cell tower where they actually found her remains, talking about the investigation as far as the recovery and the process and what was found and where it was found there. And you have a little bit later on in the testimony, you have the TBI's forensic firearms investigator talking about the gun that they find. So that testimony from those witnesses is good and it's credible and it's believable. They show, I think they show levels of competence and capability that they did a proper investigation. They followed correct procedures as far as the evidence collection was concerned. They followed good established chain of custody responsibility, all those kind of things that you would need to show in a case where you're talking about the kind of direct physical evidence and you're talking about the scientific kind of more of the technical data and evidence in the case. So there's some good parts about that parts of the state's case. Again, there are weak parts though, and the weak parts are not, I think, based upon the way the state presented its case so much as in the quality of the proof that they had to offer. I think I also tweeted about this, and somebody had asked us, like, basically kind of what do you think about the state's case? I said, well, I think they basically threw everything out there that they had to offer, and they kind of had to throw all their eggs in this one basket based upon the Jason Autry version of events, and they tried to back it up with as best they could with what they had to offer. I've got some specific thoughts about some of the sciencey type issues and some things that weren't done that should have been done, frankly, and questions as on both sides of the case as to why they weren't done and why they weren't presented, or if they were done, why they weren't presented, frankly. And a lot of that kind of stuff goes to some of the gun things, which is one of my kind of pet areas of law. I do firearms related law things and have a pretty significant interest in firearms themselves and understanding some of those things. But so from your perspective, as you're watching the testimony coming in, you say you're sitting in the box as kind of this internet home juror in the case. someone who is, you're not a professional you're not a law enforcement. You're not in those fields directly. You're not working those fields every day, but you're kind of, like I said, we talked about it. I kind of say you're a very advanced amateur on these things. You've got a very solid base of education and background and those kind of things in these fields and an interest in studying it. So
I would also say I like to think that I know enough to know what I don't know.
Oh, fair.
And, I'm going to kind of rewind it back a little bit to, talking about Clint Bobo's initial account of his witnessing her abduction.
Sure.
I'm not trying to rail on Clint Bobo. I'm not trying to call him into question or suggest that he is suspect, but one of the things that has just kind of I've not ever really been able to reconcile as when I heard his testimony is, if I heard you screaming out and yelling with someone in our backyard or in our garage, I don't think I would, even if I thought it was if I thought it was someone we knew, even I thought you were screaming and yelling with someone we knew, because that was the thing that he said, is that he heard the screaming, he heard the loud, speech and what sounded like screaming, yelling, and he thought that she might have been having a fight or a breakup with her boyfriend and all that. Well, even if you're out in our garage or our backyard or something having, you're screaming and yelling with someone, even if I think that it might be with someone we know, I would think that I would want to go outside and go, what is going on between the two of you all that you are carrying on like this?
Sure.
And so to just go, oh, they're fighting and it's, what it made me leap to is there something that we don't know about Holly and Drew's relationship, that we were not told about Holly and Drew's relationship, that Clint would automatically jump to, they're fighting, they're breaking up?
Sure.
Because the story we got from what was presented by the prosecution is that they were in love. Sure. They were committed. He'd given her a promise ring. They were gonna get married down the road. They had a future together.
Sure.
And so I feel like what have we not been told that makes us say, that makes us say that, where Clint just goes, they're fighting, they're breaking up, that's what's going on out there. Yeah. Because I feel like if it were my sister, and even if I thought she were out in the garage or outside on the porch fighting with her boyfriend, I would want to go outside and say, what are you doing? What are you saying to my sister that's got her so upset?
Sure.
And so again, I'm not casting aspersions on Clint Bobo. I'm not trying to suggest that he's involved, but that's just, that particular element has been difficult for me to reconcile. I
understand that, and I think it's reasonable to make that kind of jump in that situation. That obviously TBI, and part of the testimony during the trial basically said that TBI did look at Clint Bobo for a minute as a potential suspect and related to the whole thing,
and they interrogated him quite intensively.
Sure, and of course Jason Autry brings up, which. Again, in the context of Jason Autry's testimony, he mentions, at least in passing, that supposedly this crew of people, Shane Austin and Dylan Adams and Zach Adams, were going over to pick up Clint to show him how to cook meth. And that's a story that comes out in his testimony with no other support, no other basis, no other proof to do anything other than to say that's ridiculous and stupid. But it's a story, and
but its purpose was to tie them to that location at that time.
Sure, and it is one more aspect of the case and the way the case gets presented to by lawyers through the witnesses to the jury, that it just gives you one more thing to ponder over as opposed to clearly saying what the truth is. And that kind of gets back to one of my kind of overall issues with the way both sides of the case presented their cases. I think that generally speaking, the best way of approaching these cases is to go in as straight of a line as you can. I think that juries are generally smart. They are able to gather the details and pick out the fine points here and there that you're trying to make. You have to tell them what the story you're wanting to explain to them and get them to understand is. Tell them what the story is, what it's going to be. Then, in a very kind of direct way, give them the evidence that shows that. That's the problem on both sides of the case. The state went in a little more of a straight line about that point than the defense did on their case in chief. But still, the problem with the state's case is that there's some big holes in the state's case. There's some big gaps in knowledge, big gaps in evidence that don't really kind of back up every single aspect, every fine detail that we'd like to see, starting at the time of abduction until the time they find her remains and what happened in all those intervening points. The defense's case, the biggest problem with their timeline and telling their story to the court or telling their story to the jury is that it was too ambling, it was too rambling, it just kind of meandered all over point A to point Z to point Q to point C instead of going from point A to point B to point C and explaining kind of this theory, which primarily seems to be focused on the fact that, one, it wasn't Zach Adams at all. He had nothing to do with it. And it was Terry Britt primarily, seems to be their primary case in chief. And then falling back on the point that beyond that, there's simply just reasonable doubt. But the problem with the state's case and the problem with the defense case is kind of the same, and it both kind of falls back to the fact that there's no evidence, direct evidence, setting out the specific timeline, so they're having a hard time setting out exactly what the specific timeline actually is. And when you have that problem, it becomes who can tell the best story, who can create the most cohesive set of data and pull it together such that the logical leaps and the inferences that the jury have to make are as small as possible. You don't want them to have to make an inference or a logical leap or fill in the gaps more than they absolutely have to. You want to put all those pieces so close to each other that there's only one logical conclusion that can come from point A to point B to point C. And I'm not sure if the state has really done that. They've come close. They've gotten a lot in. And the defense's standpoint, again, I think their problem more is not on the volume, because there's only so much they can argue on a volume standpoint, but it's more kind of the meandering road they took to get there. The meandering road they took to get there through a bunch of different witnesses is probably harder to condense from a jury standpoint. So you're watching this case kind of, again, as sitting as a juror, basically, and kind of taking it from that perspective, not trying to make any judgments of the substance of things until the evidence is presented. That's kind of the way I've been trying to approach it. I'm approaching it that way from a lawyer perspective. She's approaching it from a layperson perspective as a potential juror on the case. From watching the state as it moves through its presentation of the case, from the initial law enforcement people to Jason Autry, and then kind of rounding out towards the back end of their case with this, list as long as your arm of various jailhouse snitches who say the various things that supposedly Zach Adams said in all his jailhouse confessions to everybody. What is your perspective on the way the state's case is kind of being presented, and what story has the state sold you on at that point?
Well, I mean, I guess for me, ultimately, and I guess it's because of the fact that I I do have an interest in forensic science. I do have an interest in, criminal investigation and investigational, process. So, the biggest hang up for me with the state is just the profound lack of hard evidence. We don't have, clothing items with, they discovered, things that belonged to Holly. They discovered her, her lunchbox, her purse, and her identification and all that, but none of those things generated any kind of forensic matches as far as, say, DNA or, that way that connected her to these suspects.
Sure.
And then, there's nothing that ever, I never saw the state present anything that resulted from the searches that occurred at the Adams residence, or any of the searches that were executed on Shane Austin's residence. Nothing that said, okay, here's a piece of bloody fabric that this is Holly Bobo's blood, or here's a piece of clothing that belongs to Holly, but it has one of these guys, semen on it, or anything like that just directly tied them to it. So that has been problematic for me. And the fact that the timeline has been almost completely generated by Jason Autry's testimony.
Sure.
And then also the fact that, and then you get to the jailhouse snitches. And, there was the point that the defense made on, cross-examination of either one or multiple of these jailhouse snitches, which was basically that, people talk big in
Sure.
jail. There's a jail and or prison culture that a lot of average people don't understand and can't really, fathom. And, there's a lot of posturing, and there's a lot of big talk that goes into, kind of putting yourself in a position, so that you're, in a position of strength and not a position of weakness, because those whole structures exist in jail and prison culture. So, it's, and on top of this, these are jailhouse snitches. These are criminals. These are people who have kind of that have had a history of, committing crimes, being deceptive, perpetrating things against other people that are harmful, so it's, you've got that thing where you have a hard time of giving that a lot of credence.
Yeah, the state's in kind of an unenviable position in presenting this case. They now have a body. They have the remains or partial remains from Holly, and they have the primary story from Jason Autry, and they kind of support it. The state is in the very unenviable position of being forced to rely on the testimony of people who are historically rapists and drug addicts and dealers and drug manufacturers for meth and thieves and felons and other general kinds of ways. They're forced to have to kind of bump up the credibility. And it's like, oh yeah, these people did all these bad things, but you should really believe them now because they're telling the truth now. And the problem the state has in this situation is why? Why should we believe these people who have had this history of doing all these terrible, horrible things that we don't allow and we don't permit in a civilized, decent society? Some of them have immunity deals, and you get to cross-examine them and say, you're testifying with me today, aren't you, Mr. Victor Dinsmore? Yes. Okay, great. Jason Autry's got federal immunity on the gun-related charges and things of that sort, and who knows what kind of arrangement he might have as far as prosecution on the state side, in addition to the other people throughout the course of the case.
And I think that can be said for all of these jailhouse snitches, is that even though there may not be an explicit deal on the table for them, you know, you have to expect that there's almost kind of a fingers crossed attitude of like, well, let me get in here and let me do the state of solid on this case, and they'll help me out in my situation.
Sure, and I think the defense actually did a decent job on cross on most of those folks in that aspect and presenting that. The jury said, listen, this guy that's testifying, he's got a self-interest in this. He's motivated to testify how the state wants him to, you know, even though the state tried to kind of say, well, you know, you've already completed your sentence, or you've already done this or that, and that's already set in place, isn't it? We haven't promised you anything. Well, no, of course not. I'm just here to tell the truth today. Well, maybe you are, maybe you're not, and I think that ultimately comes down to how the jury takes these witnesses. Some of those witnesses were better than others. You know, a lot of them came across as fairly believable, despite their
checkered,
colorful past. But, you know, it's still weak. It's a weak circumstantial case. You've got testimony from people who have a history of lying and a history of doing criminal bad things, and you're relying on them to prove your case. So, you know, the state, I think, did, on the whole, probably about as well as they could have done in presenting the case that they had to present. You know, I think that there is a significant kind of lack of evidence that they had the ability to present. I think that there were likely choices made in what to present from the state's case in chief on this. There are things that are missing that I think, frankly, we would have expected if the evidence was good, or at least certainly not bad. One of the things, and I wanted to talk about it just because it's, like I said, it's the gun thing that made an issue for me. You know, as much as the teeth and the bones and those kind of forensic-y kind of things are things for you, the gun stuff is things for me. So the story that the state is presenting, and obviously that the defense is kind of trying to argue against, and I would argue that both sides did it very poorly, was related to the gunshot and the wound that was evident in Holly's skull and her remains. It was found. I think that both sides did a less than sufficient job in both presenting it as clear and definite proof that someone did something to her. Obviously, someone shot her. It's very clear it's a bullet wound. I think the pathologist's testimony is enough to show, yes, this is a bullet wound. There's a bullet wound you see in the bottom right corner of her skull, and there are fracturing lines extruding north and south from that, and internal flaring out on the inside of the entrance wound, and then there's demonstration of an exit wound on the front of her face. I think that,
and you know, and again, the entrance wound is always significantly smaller than the exit wound, and so the damage to the front of her skull was much greater than the entrance wound in the back of her skull.
So there's questions that I have about that, and I believe, and I haven't gone back to review the pathologist's testimony specifically. It was just the recollection from when I heard it live in real time as it was going. My recollection from the pathologist's testimony on direct from the state was the diameter of the entrance wound was 0.36 inches in diameter. And so that's a question. What type of firearm round, what type of cartridge being fired, and the bullet coming out of that cartridge is going to leave a wound, an entrance wound of that size on the entrance side? So there was some question that came through. The defense tried to rebut some of the proof on that and did a very bad job of it. Yes.
I'm gonna stop you. Let's talk about the various shell casings and spent casings that were found in and around the site where her body, where her remains were recovered.
Sure, I think there was a decent job explaining kind of the general terrain of the area. It's rural, it's wooded, it's an area where people would typically be out hunting and doing kind of outdoorsy kind of things.
And that's one thing for anybody who might be watching that isn't from Tennessee, isn't from rural West Tennessee or rural Tennessee or the rural South, for that matter. You know, if you've got a big patch of woods, a lot of times people go out, they'll go out hunting. They may just go out target shooting, or if they go out just hiking, a lot of hikers will carry a firearm that will protect them from snakes or coyotes or other vermin.
Sure.
So,
and I think that's important too in this case. Is I think that those things are all relevant, and there's very little testimony about what that is. So the forensic special agent for the TBI who did the investigation and the collection of the remains in that scene testified about the cartridge casings that had been found at that area, kind of within I guess the scope of their search area where they were finding her remains. They found a 308 cartridge casing. They found a 410 shotgun shell hull, and they found a 380 ACP, 380 automatic pistol cartridge. So explaining what those things are a little bit for people who don't kind of get what those mean. They're just numbers and they don't really mean anything. What's the difference between a shotgun and a pistol and a rifle? Well, most people can get that, a shotgun versus a rifle versus a pistol. Well, the 308 round, a 308 round is a very high-powered rifle round. Used a lot of time in hunting, especially big game hunting, deer, things of that sort. Deer hunting would not be an uncommon occurrence in this part of the world. In that
particular part.
Certainly. So a 308 rifle round, very high-powered, very large round from a bullet mass standpoint.
It would do an incredible amount of damage.
Absolutely. A 308 round from pretty much any kind of range is going to do a massive amount of physical damage to human tissue, skin, skull, everything else, or any other part of that. That's why they use it to take down deer and various other things. So the 308 round can readily be discarded in any kind of context in this case because we don't see that kind of damage here on the remains that we have anyway. It's not that there's not damage on the ribs to show evidence of bullet wounds. The only bullet type wound we have from the only confirmation that she was shot is the bullet wound to the head. Correct.
So I mean, is it possible
that she had another
that she was shot in some other portion of her body?
Sure.
It is entirely possible. There's no other damage to the bones that were recovered that would indicate that.
Sure. And the likelihood of using a 308 rifle, 308 caliber rifle, to do that kind of murder, that kind of killing from something that's likely going to be something up close.
That would just be awkward.
It is probably infinitesimally small that was likely. The likeliest source of that round comes from something that was left over from a hunter who didn't pick up his brass when he was out hunting. That's the likeliest source of that. So to all the hunters out there, if you don't want your stuff getting found at a crime scene, pick up your brass when you go hunt or go shoot.
Don't litter.
That's it. Same thing with the 410 shotgun round. The 410 bore shotgun is a shotgun, so it is not a rifled barreled firearm. It's a smooth bored firearm. You know what a shotgun is. You've seen them, even if you don't know anything about guns. You've seen shotguns. Grandpa probably had a shotgun that he kept by the door of the house. Well, if you lived in the South, I know he did. But a 410 shotgun bore is a very small gauged. We talk about 12 gauge and 20 gauge shotguns. Those are larger diametered shotgun rounds. A 410, it's not even 14 gauge, it's 410 bore. It's a much smaller shotgun round. Can be used in regular shotguns just like any other thing, but it's very small. One of the typical kind of current usages of that, though, is there are firearms, revolvers, that will actually carry a 410 shotgun round as a revolver round. Firearms like the Taurus Judge, the Smith & Wesson Governor, you can just load those straight in a revolver and use them as that kind of as a round. A lot of people use those both in hunting for small game kind of things, but also we talk about hikers and things like that.
Called snake guns.
Yeah, you're going out and you walking through the woods and you come upon a snake, and then we don't need the snake anymore, so boom, let's use the 410 and do it that way. Obviously, there's no evidence from the remains that we have from that scene that there's any evidence of any kind of shotgun type wound, because those are also spreading kind of wounds. They're not, are spreading kind of patterns. They're shotgun shells include typically lots of small projectiles within inside the one cartridge.
Pellets.
Yes, depending on the type of shotgun round it was, depending whether it was a slug. It could have been a slug, possibly, I guess, but most likely it was pellets of some sort, BB sizes, up to some larger buckshot type sizes, which are a fair bit bigger than that. But the likeliest source of that 410 shotgun shell is, again, some random hunter, some random hiker, some random other passer through the area who is doing that. So from the firearms casings that are left and found and recovered at the side of her body, the thing that is left is the cartridge from a 380 automatic, 380 ACP pistol cartridge round. That particular round is a commonly used small caliber pistol round. Those pistols are typically used, most people that are law-abiding carry those as personal self-defense kind of weapons. They're small, typically readily concealable, fairly lightweight from those kind of perspectives. The round is fairly small as far as the weight and the size, both on the charge behind it and the size of the cartridge, or size of the bullet itself in the cartridge. So,
and the actual firearm is actually,
yeah, the firearms are typically very small and compact as far as that kind of thing goes. But with a 380 ACP round, the diameter of the 380 ACP round is standardized. It is and that's the thing with pretty much all firearm rounds, rifle, pistol, shotgun, and all those things are fairly standardized, and there's a standardizing agency that sets those things. That's so that manufacturers, when they're manufacturing firearms, know the precise kind of dimensions of the cartridges that are designed to be fired in the firearm, so we have consistency, so we don't have catastrophic failures of the firearm. So all those
because
things,
not all ammunition is manufactured by firearms manufacturers.
Yeah, and it's typically different people doing that. It's typically the firearms manufacturers do the guns, and then the ammunition folks do the ammunition. There's some crossover there, but yeah, that's right. So we have this kind of standardizing agency that is set up. It's called SAAMI, SAAMI. You can find their website at SAAMI.org. They've got listings of all the kind of technical specs and details about all those firearm rounds. The thing about a 380 ACP round is that the diameter of a 380 ACP is 0.355 inches, and that's the diameter across the width of the bullet itself. That's also the same size as a 9mm. You've heard people talking about 9mm. You don't know anything about guns, you still heard of 9mm. 9mm Parabellum, 9mm Luger. It's all the same. They're just different names for the same thing. It's the same diameter as the 380 ACP. So a lot of times the 380 ACP is also called the 9mm short because the cartridge is a little smaller. Or the cartridge is a little smaller than a 9mm Luger. But they're both the same size, 0.355 inches across. And why is that important, at least in my assessment of things in this case, from a science and from a data standpoint? I'm not a firearms guy. I'm not a firearms expert. I'm not a ballistics expert. I am a gun lawyer. I like guns. And this is just my take on things as the case was presented. As I remember from the pathologist's testimony, the entrance wound that was found in Holly's skull, as it was found, was 0.36 inches, incrementally fractionally smaller than the 0.355 inch 380 ACP round or a 9mm round. Most likely 380 ACP, because here's the connection. You have to believe Jason Autry's story to believe that Holly was killed at a different location, and then her body was later brought to this spot where her remains were found. To look at what is logical in this case, one of the logical versions that you could readily come to is that no, Holly wasn't shot there. She was shot with the spot where her body was left. it makes more sense to me from a practical standpoint. Why would you shoot her and then drag her around in that situation? In that situation when you weren't going to dispose of her body where you shot her, it seems reasonable in that situation. There is a 380 ACP cartridge at the site where you find her remains. The 380 ACP round diameter is 0.355 millimeters with a 0.36 inch entry wound at the same location seems to me to be entirely consistent with that kind of firearm and that kind of cartridge at that location.
And the fact, again, we spoke to those other cartridge casings that were found. Those are indicative of firearms that are used in the woods for, hunters,
Sure.
hikers, whatever.
Sure.
But, your standard 380, again, it's typically a concealed carry, personal protection firearm. It's not the kind of thing you're going to go out in the woods and shoot.
Yeah, it's not a game collecting gun. It's not going to be generally used by someone from a standpoint of going out in the woods as a hiking gun to protect for snakes, because it's not really designed for that. It's a small caliber pistol. Well, if you're a really good shot, I guess you can shoot a snake with a 380 pistol, but it's typically not going to be something you would expect.
It's not the most effective tool.
It's not the most effective tool for that job. So what's the difference between the 380 ACP casing cartridge that was found at the site of her remains were recovered, and the gun that the state has alleged in their case and has been seriously pounding on the fact during the entirety of their case and in closings that they allege to be the murder weapon. Well, the murder weapon they claim is a 32 Smith & Wesson pistol. It's a 32 Smith & Wesson caliber pistol, and it's an Arminius HW5, I believe is the model number. It's a revolver. It's a 7-shot revolver designed to carry the 32 Smith & Wesson round. Allegedly, and well, of course, when the gun was recovered, the state's firearm expert was very clear in indicating that it was loaded with 32 automatic rounds, which is a little uncommon because you typically don't put automatic rounds into a revolver. They're not really designed for that specifically, but it can be worked in this particular gun, in this particular round. So in that particular revolver that was found, it's a 7-shot revolver, carries 7 in its cylinder. When the gun was recovered, there were only 5 rounds in it. Okay. So there's a couple of plausible alternatives to this story. Okay, this is the firearm that was used to kill Holly. That's the testimony Jason Autry used. It's the testimony Victor Dinsmore gave when that shortly after that morning they came and traded this gun to me for drugs, and then we disposed of it when we, quote, figured out that it had a body on it, which is kind of appalling to me. But that's neither here nor there. So what's the deal with the 32 ACP round? Getting back to bullet dimensions and things of that sort. And this, God bless the defense, they really tried badly on this point. They didn't have an expert. They had a former military guy who's a private investigator now, who looked like he pulled some stuff off of Wikipedia and out of his gun locker, and took his ruler out and tried to measure stuff and did a really just appallingly bad job for the defense on that part of the case. The dimensions on a 32 ACP round is 0.3125 inches. That's the diameter. It's significantly smaller, especially in the context of the diameters of bullets. I mean, tiny fractional increases in the size. I mean, hundredths of an inch are significant size differences enough that they won't run in a certain particular gun. So a 0.3125 caliber or 0.3125 inch diameter bullet, leaving a 0.36 entry wound, especially when we're talking about a close range impact. It's possible. I'm not saying that it is impossible that firearm is the firearm that caused that wound. But if you think about it from a dimensions standpoint alone, the math just on the size of the dimension, you would expect that a 0.3125 wound is going to be smaller than a 0.355 wound. and the .35 in the entry wound in this case is .36, which is virtually the same as the size of a .380 ACP round. Nobody's found a .380 ACP pistol or put a .380 ACP pistol in any one particular person's hand, whether that's Jason Autry or Shane Austin or Zach Adams or Terry Britt or Dylan Adams or anybody else in the world that might have done this. Both the state, from a standpoint of presenting proof related to what the ballistics were actually done and why this wound is really consistent with the gun that they're alleging caused the death, or the defense from a standpoint of trying to refute that with any quality ballistics proof, I think is a huge gap and a lacking factor in this case from a proof standpoint. I think that from a defense standpoint, it's really a seriously lost opportunity to actually present really good proof in this case that could seriously bring the case into reasonable doubt, even beyond reasonable doubt. I mean, even significantly doubtful that he was the one or that Jason Autry's story is true. If you've got really good, competent testimony from an expert, a firearms expert, plus a pathology expert who can explain the sizing of bullet and entry wounds and those kind of things as they relate to firearm caliber. There's plenty of science on this. There's different studies. You know, I took 5 or 10 minutes and poked around and found a half a dozen like actually peer-reviewed studies online. Didn't read them all, but there's plenty of that stuff out there. There are experts in these fields who you could bring in to testify about these things. And if you testify about those things in a good, competent way and present that proof in a good, competent, clear fashion to the jury, it gives you, from a defense standpoint, it gives you some reasonable doubt. It's like the state's saying it was this gun. My expert's saying there's no way in the world it was that gun. The likelihood it was that gun, taken in conjunction with the fact that we never found a spent .32 ACP cartridge, which is admittedly very small, very, very small. We never found that. Combine those two things together gives you enough to say Autry's version of the story doesn't make sense. We can't say that it's true. Tying up my points on the firearm stuff, the other thing that troubled me is that there's no proof that anybody, from an investigation standpoint in this case, from a law enforcement investigation standpoint in this case, once they determined that there was a bullet wound, and once they recovered her body, once they had an idea of what they were looking for, especially after they get Jason Autry's version of the story, there's a location where it's at least reasonable to conduct a search to try to find a .32 ACP spent cartridge somewhere. If you can recover that cartridge, granted it may be the most needly of needles and haystacks. If you can recover that cartridge, though, either from the site where the alleged killing itself actually occurred, or from Zach Adams' home, or from Shane Austin's trailer, or from the barn, or from Grandpa Adams's home, or from Victor Dinsmore's home, or any number of other locations. Expand the scope of your search radius and go look for this thing, because that would actually tie be somebody who took bullets out of the same box of ammo they got from the store, shoving them all into the gun at the same time. So typically you're going to find that. Their state's ballistic expert could have shown the firing pin and the way the gun fires and the impressions that the firing pin makes, the various other parts of the ballistics that just weren't done. And that's a big gap in the state's case from an investigation standpoint. It kind of goes back to some of the things about some of the things that are concerning about the case on the whole from a
quality of investigation,
due diligence of the standpoint of the thoroughness of the investigation. Yeah. So that's the guns. Okay. Rant over on the guns.
Rant over on the guns.
Rant over on the guns. But I do think it's relevant, and it shows lacking on both, kind of from a technical standpoint on the science part of it, and some significant gaps on the lawyering parts of things on the case.
All right, so we've kind of covered the state's case.
Yeah, I think we got through the bulk of the state's case. Obviously, like I said, and they're resting most of it on the testimony of a bunch of people who are.
I would say, like 65 to 70% of their case was on Jason Autry.
I would agree with that.
And
at least.
and
the rest of it's trying to buttress up his testimony.
Yeah, exactly. The other guys are just really trying to give a little extra, support to what he's saying.
Sure.
So maybe at this point we shift to where the defense has gone forth.
Wow.
And
we know, and we've talked about, and everybody talks about on Twitter, and everybody talks about online, and all the news media talk about online. That's obviously it's the state's burden of proof. The state got to prove their case beyond a reasonable doubt. That is true, and it's absolutely correct, and it's absolutely correct statement of the law. Substantively, though, in a case like this, defense-wise, you have to prove some kind of, and I call it kind of a plausible alternative theory to the state's case. You have to prove something that is at least plausibly believable that you can prove.
Well, you can't, as a defense, you can't just sit back and say, my guy didn't do it.
Yeah.
You have to say, my guy didn't do it, and here is why, because this other person did it, or there was this other set of circumstances that happened.
Sure.
You have to set up, like I said, you have to set up the alternative narrative.
Yeah, it's the plausible alternative theory that shows really that this other version of the story is at least plausibly true. You don't absolutely have to prove it as a defendant. You don't have to prove it wasn't me, it was this guy. But you have to make a story out to the jury to give them enough to say, you know what, at the end of the day, I think the state's probably right on their case, but you know what? This story rings just true enough to me to give me some reason to actually genuinely doubt this. Not just a mere passing hope that it's true or some mere passing possibility that it's true, but there's enough meat on that bone that I can say I have a hard time convicting this guy because this story is true. So the state is hanging their proof, or the defense is hanging their proof and hanging that theory primarily on the proposition that Terry Britt is the actual
perpetrator of these crimes against Holland.
Absolutely. So to get to that point, they get with Terry Dicus. Terry Dicus, former TBI agent at the time, was the case agent in charge of the initial kind of investigation.
Almost 2.5 years.
Sure.
From the beginning through 2.5 years into the investigation.
And so I think a lot of stuff has come clear and made it clear about Mr. Dicus is that he obviously is no longer with TBI, and there were issues related to his leaving TBI. He's now in private practice. He's an attorney in Savannah, in Hardin County, just down from the courthouse where the case is going on, where the trial's happening.
Now we know like within at about approximately 2.5 years into the investigation when he was removed as the case agent. I never ever got the confirmation of when he actually left the TBI. So I don't know if his leaving, I never heard that confirmed in testimony, and I never found any information related to that in any of my research. But, sure. So I don't know how his being removed from the case as the case agent and his subsequent leaving of, how close together was that? Did he leave the TBI because they removed him as a case agent? Was there was he demoted to such a degree that he just said, I'm leaving?
Sure.
Or was it something that happened, some extended period of time beyond that? But we know that he was the case agent, which is basically kind of the investigation leader.
Sure. For
this case, for the first approximately 2.5 years after she went missing.
Sure.
And he was removed, and we found out in the states in the states in their their cross. Well, no, it was when they called Agent Van Hooser
in the rebuttal case,
because that was one thing. Is, there was the allusion to the fact that he was removed from the case during his testimony.
Sure.
When he was questioned by the defense, but the precise reason why he was removed never really kind of came out explicitly.
Sure.
And I always had my suspicions based on his testimony related to Terry Britt and the way he was particularly focused on Terry Britt as a suspect. I had my suspicions that it was the fact that he was particularly hung up on Terry Britt as an investigator.
Sure.
That for whatever reason he didn't want to let go of Terry Britt as the actual suspect in these crimes against Holly Bobo.
Sure.
And that was actually confirmed to a large degree when the state called Agent Van Hooser.
Sure.
And he did explain and he did confirm that, Agent Dicus was removed, and he was removed because he was almost singularly and obsessively focused on one suspect, and to the point of losing all objectivity. That was almost a quote of what he said.
Yeah, I think that from a standpoint of the lawyering presentation of Terry Dicus's proof in this case, the defense is in a little bit of a weird position of putting him on the stand. He is not outright hostile to their case, and in fact, in a lot of ways, he's actually very helpful to their case. I think the way the testimony came across, as I'm listening to it, I get Terry Dicus's perspective into the case. I get his view of the case and kind of a general view of his approach to criminal investigation, the way he approaches these cases. You can question that. You can say it's right. You can say it's wrong. I mean, law enforcement officers and investigators, like any other kind of professional field, are going to have different approaches and different ways that they think things should be done. There's certain kind of minimum standards that you would expect out of certain people, and maybe he did those things in this case, maybe he didn't. I think that his testimony as a whole was a little stilted. It came across that it was rough in a couple of spots as far as some vernacular that I'm not going to repeat here.
There was a certain term we didn't think we would ever hear stated in open court.
Never heard that in court before. Would hope to never hear it in court again, and not going to repeat it here. But if you were watching the trial, you heard it and were by it. And but there are parts of his testimony that make sense and that tell a story that the defense is trying to sell, which is that Terry Britt's the guy who's good for this case, not Zach Adams. The story with Dicus is
well, and I'm going to stop you just for a second. I think Dicus creates a big. He's kind of a sticky wicket for both sides.
I agree.
Because, he's got, he went down a line of investigation through his, while he was in charge of the investigation, that, again, his focus on Terry Britt and his suspicion that Terry Britt was possibly the one who perpetrated these crimes against Holly Bobo. Obviously that is beneficial to the defense as an alternative narrative, but at the same time, he was a part of the investigating agency that ultimately found Zach Adams to be one of their primary suspects.
Sure.
So, it's this kind of, I feel like this is weird line you're walking where, you want to give him some credibility, but then how, if you give him credibility, do you end up conferring some credibility to the TBI on behalf of the state?
Yeah.
And then there's kind of the flip side of that. The state wants you to believe that all the investigational efforts of the TBI were, you know, above board. They were, you know, on par with what is considered to be, you know, the, you know, the most, you know, utmost level of investigation. But then he's coming in with this, and they go, but don't listen to that guy.
Yeah.
You know, so, but that guy was a part of this same agency that you want everybody to believe, you know, so that, I mean, he really created, he really kind of created a weird line in this case.
And presumably in the case, and I don't think we really got into a lot of detail in the testimony about Terry Dykes' history in law enforcement, his history with TBI. We don't know how long he's been a law enforcement officer of any kind. Presumably, he had been in law enforcement at some point prior to joining the TBI and becoming a special agent with TBI. And presumably, he was just a field agent, standard field agent at some level lower than the level he wound up being on this particular case prior to becoming that. So he'd been with the agency long enough, or the Bureau long enough, to have developed probably some seniority, probably an extended period of time where he was progressively more responsible, and that's a demonstration of, hey, he's, you know, he's advancing along the lines.
I mean, he was in a supervisory position.
He was the guy. He was basically the next guy in charge of this investigation. He was the guy primarily in charge of the investigation, and the only person, I guess, really immediately above him that he reported to is the special agent in charge, who eventually winds up being Agent Van Hooser.
Mm-hmm.
I think John Mayer was the special agent in charge at the original time. And John Mayer is now the sheriff in Madison County, Tennessee, which is in Jackson. I think he was the special agent in charge at the time the initial part of the investigation was
and if anybody who's viewing this isn't from Tennessee, I would say, kind of as a general rule for Tennessee Bureau of Investigation, you don't just up and decide you're going to be a TBI agent. I mean, that you know, you typically TBI agents are they are hired from lower level law enforcement positions. Typically, if you've worked your way into being a TBI agent, unless maybe with the exception of some of the forensic, scientific, laboratory, you know, positions, but from a specific, like, you know, as an investigator, as a general rule, you know, those people have worked their way up through smaller, lower level law enforcement agencies. They've either started in, you know, police departments or sheriff's departments in specific counties, and then they've taken their experience there and they've applied to the TBI, and they've become, you know, special agents in the TBI. And with most government agencies in Tennessee, and probably a lot of government agencies in other states, there are tiers of experience. You know, there's entry level, and then you work your way up through various levels of supervisory positions. So he was, you know, Terry Dykes was at the point that he was in charge of this case, he was in a fairly
supervisory position.
Yeah, he was in a higher level supervisory position. So he's not just some random Joe guy that's, you know, doing this.
I think the biggest problem with his overall, from the standpoint of presentation, his case was that the state did a fair job, especially on cross, in trying to kind of make him look ridiculous from a standpoint of, you just didn't do anything. You keyed in on this one other guy, and you
just got tunnel vision.
You had tunnel vision to this one guy because you just had you were set out to get him, and to the exclusion of everyone else. And he has an alibi, and this alleged kind of alibi, or this kind of evidence that you have through cell phones or whatever other basis it is on Adams and Austin and Adams and Autry is all, you know, it's ridiculous. You need to go after these guys. You need to get all the proof on those guys. You know, the state did a pretty good job, I thought, in getting after his testimony and kind of deflecting some of it. But I still think the defense did a fair job in trying to show there's a legitimate guy here who is a legitimate, plausible alternative suspect in this case. through Terry Dykes' testimony. They went through kind of a laundry list of a bunch of other people, which I think is also a good thing from a standpoint of explaining it to the jury, from a standpoint of showing, no, basically Dykes wasn't completely exclusively on Terry Britt. He actually investigated these other people. He investigated a list of sex offenders and other random people in the area that might have some tie to this, and they went through those in not exhaustive detail, but decent detail, depending on the level of significance of the investigation they were. But they did a good job with that, and actually kind of laying out the case that no, Dykes, his investigation was okay, and Britt is still likely a good suspect for this crime, by saying he actually did do the work on this. His assessment of it, as a law enforcement officer who'd been there obviously a while, was in charge of the case, was that the Adams brothers and Austin and Autry did not do this crime, and that Terry Britt probably did. His testimony on the whole, I think, was on the slightly positive to the defense side versus more or less neutral to the defense, or to the state's case. It was just very slightly close. It was kind of down the middle of the road as far as the net effect of it. It opened up at least a door to allow this alternative theory to come in a straight-faced, at least slightly credible kind of way.
Well, I think he basically offered the last best hope for any kind of reasonable doubt for the defense.
Sure.
With presenting, the testimony regarding Terry Britt.
Sure.
And this is the thing. I'm gonna pull you aside and kind of go off on my tangent about Terry Britt.
You go on your Terry Britt tangent.
The Terry Britt thing kind of really stuck out with me. Another one of those things that just kind of stuck with me that I just couldn't really let go. And, I may be wrong. Somebody may see this and they may be able to tweet at me and tell me where I missed it. Agent Dykes' testimony was fairly lengthy. So, but I didn't remember, in the course of listening to his testimony, I heard him run through the laundry list of other suspects that they considered. And I heard him, the defense question him on those individuals. And I heard him give the reason why they ultimately eliminated those people as suspects. They confirmed alibis and that, all these things. But I never really heard from his testimony the specific, precise reason why the investigation shifted from Terry Britt. He talked about him believing that Britt's alibi was garbage. That's a quote. He said it was garbage.
I agree.
We know that Britt's alibi was hinged basically on what his wife said, which that's kind of a common, that's common investigational technique of, when your only alibi is a spouse or a girlfriend, there's typically additional efforts made to try to, corroborate that. And, if the random guy at the grocery store who doesn't know you from Adam gives you an alibi and has no reason to, lie for you,
sure.
Then maybe that's more legitimate. But when it's your girlfriend, your wife, or whatever, then sometimes there's often a lot of effort to add, some additional corroboration to that. There were just, you talking about his route that he claimed that that Terry Britt, claimed. There's just a lot of things about his alibi for his whereabouts that day that maybe didn't add up entirely. Yeah. So I get where Dykes was coming from on believing that Britt's alibi was garbage, but I never really heard from his testimony why they walked away from it.
Yeah.
In the same kind of definitive way that they described for other suspects.
Sure.
And so then you couple that with the knowledge of him being removed from this case as the case agent. And then you couple that with the knowledge that you hear from the testimony from Agent Van Hooser talking about him getting singularly focused on one, person. Now, this is when Terry Britt was brought to testify for the state, it was established that he was currently in prison. I mean, he came in, he was in, prison scrubs. He was currently serving a prison sentence. And though the prison sentence that he is serving is related to kidnap and rape charges that occurred in the actual event, the actual kidnap and rape that he was charged with occurred in 2008. He was ultimately indicted 10 months after Holly Bobo's disappearance for that 2008 event. And then we I know I'm jumping all over the place, but then we talk about U.S. Marshal Walker, who interviewed him at the behest of Agent Dicus. And we know that when Agent Walker was interviewing him, he was interviewing him in a jail and/or prison environment. He was incarcerated. And my concern was that there was so much community pressure, political pressure to close this case, to put, to wrap this up, to put a face to who did this to this poor girl, that knowing that Terry Britt's already in jail on these other charges.
Yeah.
I felt like there was a bit of a concern that if he was the one charged, it would be it would kind of go out with a fizzle instead of a bang. And that there was almost this notion, maybe perhaps that the state and the TBI and the DA and all of the, agencies involved in the investigation and prosecution of this crime, they wanted the perp walk. They wanted the dramatic finale of, we found them. We found the guys. We've come to the conclusion. These are the terrible people who did this. And to just go, oh, well, it's this, already convicted rapist and, kidnapper who's already in jail, it just didn't give the same, and I know I'm reaching really hard on that. And I know that I'm going down a line, but, I never heard why Terry Britt was ultimately excluded without a doubt.
Yeah. I mean, I think the state's view of that is, and TBI's view of that is, that they believed his alibi story. And I think that's, at least in the roundabout way, I think the way it was brought in. So that's one of the things that I wanted to talk about. Your transition over to talk about Terry Britt was perfectly timely and appropriate, because that's kind of one of the things I was kind of thinking about talking about next anyway, is that I do have issues, and I think I have the same issues with Terry Britt's alibi from a proof standpoint, from a lawyering standpoint, as far as the evidence being presented in court, that make that problematic. The story that he gives when he's testifying is that he could not have done it. He did not do it this morning, because that particular morning he was with his wife and they were traveling to another town in Camden, Tennessee, which is probably 30 or so miles up the road, give or take 30, 35 miles up the road, depending where they're going, where they're coming from their house, to go look at a bathtub, because they had a bathtub leak at their house and they needed a new bathtub. Okay, fine. That's a perfectly plausible potential story of something you would have been doing on any random morning of the week when you needed to get a tub. But his version of the story strikes me as odd, just from knowing the geography of the area, because he says in part of his story is that they left from their home in the greater Parsons area of Decatur County, off of Jeanette Holiday Road, and drive up Highway 641 the 30 or so miles up to Camden to All Goods Salvage to look at bathtubs to get a replacement. When they get there, they look and they find something, but they're not real sure. So they decide to drive all the way back down to Decaturville, Tennessee, to another supply store there, which may or may not have actually even had bathtubs in stock for them to look at. And then they decide to go all the way back again to Decatur or to Camden to actually purchase this tub. And here's where the case from that part of the proof standpoint kind of falls apart, because ultimately the truth and veracity of that alibi and that statement of events is really only tied up through Terry Britt's testimony and some of the other law enforcement officers kind of saying, yeah, we checked it out, we believed it. There's a lot of aspects of this proof that just didn't come into the trial, didn't come into evidence that should have certainly should have come into the evidence in the case. And I would give the defense some negative marks for not trying to get some aspect of the proof in. So logically, from a geography standpoint, not to have a defense counsel bring up another map, because I know that was a significant point of criticism by a lot of social media and a lot of people observing the trial, especially during the Jason Autry testimony. But the map on this situation is really clear. The trip from Terry Britt's home there on Jeanette Holiday Road outside of Parsons, kind of in the Darden area, down to Decaturville, if he wanted to go look at tubs, the logical thing, at least to my mind, is that if you're going to look for tubs and maybe you're going shopping that day and you want to buy tubs, okay, you got a couple of places you want to check. You want to check Decaturville, you want to check in Camden. Okay, fine. The first place you're going to go is to the store in Decaturville because it's close. It's like less than 10 miles or so from his house. It's going south from his home down Highway 641 out to Decaturville. It's close. It's right there. You know what they've got in stock. You know how much the things are going to cost. If you're not sure that that's where you want to buy, then you decide, I'm going to go to the store in Camden, which at that point then is about 45 miles. So it's another, it's 35 or so miles from his house to Camden, and then it's another 10 or so down to the south of there, going south that way. So in that situation, you're driving from your house south 10 miles, and then you decide to go to Camden, which is north another 45 miles. So once you get to Camden, at the store there, you've seen the products at both stores that you're thinking about buying at. You're either going to buy something from the store in Camden, or you're going to buy something from the store in Decaturville. If you're going to buy the stuff in Decaturville, you just go on back down to Decaturville, and then you're closer to home when you get done. It's there, it's closer, it makes more sense to do it that way. If you're going to wind up buying something at the store in Camden, why would you go to Camden first, then to Decaturville, all the way back down? So you're driving 35 miles north to Camden, driving 45 miles back down to Decaturville. Then you're driving 45 miles back to Camden, then 35 miles back home once you've purchased the tub. The logic of it just doesn't seem to make sense. Not to say that every person's going to think and act the same way that I would. I try to map those kind of things out so I don't waste a bunch of time. Maybe Terry Britt's got all the time in the world, or had before he's now locked up again. But maybe he's got all the time in the world now he's locked up. I guess he does. But logically, it just doesn't seem to smell right to me. Something smells off with that, and it smells manufactured. You combine that with the apparent proof of his alleged receipt for purchasing the tub at the store at All Good in Camden, which he had locked away in a safe at his house. Discounting the fact that someone would put a receipt inside a safe at their home for a tub. It's different if it's something that you might have to return or something like that, where you might want to keep it safe. Or
something you carry around, it might get damaged, or whatever.
It seems odd that you would put that in the safe. So combined with the fact that the testimony that sort of came in but didn't really come in about the way they write the receipts at All Good Salvage, they have a carbon pad on their counter where they fill them out and write it out, and you get one copy and the store keeps the other one.
And I think that's one of those things where the defense really missed an opportunity. I mean, I think they missed an opportunity to one, bring someone from possibly from All Good Salvage to verify that. Yeah, I think we didn't. We have no we have no record of this guy. We have no record of this receipt. none of our staff members or our employees have any recollection of ever serving or waiting on him
Sure.
or selling him this tub.
Sure.
You know, there could have been possible like handwriting analysis as far as the
receipt itself.
The receipt itself.
Sure.
Does it match any of the handwriting of anyone that works at All Goods, or does it match?
Does it match Terry Britt's or his
wife or whatever?
Yeah.
I think that the defense really missed an opportunity to, again, just add an extra layer of.
It's not just the opportunity to do it. It is the opportunity, but it's not just the opportunity. It's kind of the obligation to do that. And I think there's been a lot of that in the trial as a whole. There's been a lot of less than full and complete sets of proof put in, and not just on the substantive, like tangible pieces of evidence that there might be and things like that. I'm talking about there are gaps that we've got that have a very clear way to fill those gaps, like this particular one. This particular one, from a lawyering standpoint, there's a couple of very clear ways to get this proof in. We got Terry Britt testifying. Of course, his wife's never testified in this case about what she was doing that day, but we've heard a whole bunch about the crap that she was supposedly doing, that she's supposed to have worked that day but just magically called in for some reason that morning. Maybe some issues with some phone calls between her and her husband on the phones, that Terry Britt never owned a cell phone. Some of those kind of things. We don't have proof from anybody from All Goods Salvage where he supposedly bought this tub. We don't have anybody. We don't have proof from supposedly the accountant for the store had the receipts and everything, and they gathered them from the store. So we don't have anything about chain of custody issues to verify those kind of things as far as the existence of those documents, to authenticate that no, we didn't lose any. They gave us everything they had. They always give us everything they have. Here's how they do this in giving us everything they have. That testimony doesn't take long. It's just a few minutes of testimony to document their processes and procedures to show this is this. But it backs that in if that's a potential alternative narrative that is plausible to present to the jury. Same thing about the store in Decatur. We don't know anything from a timeline standpoint other than what people are just saying.
He went there.
He's saying he went there. We don't have any proof from anybody from that store talking about, yeah, we saw him here, or yeah, we've got surveillance cameras, we've got video of him being here at XYZ time. We don't have any of that kind of proof, whether it exists or not. And I know you don't want to muddle things up with stuff that doesn't exist, but some of that proof needs to come in. Even if it's the 3 questions of who are you, do you know the things about this store, and did
you see this guy here?
Do you have any proof of, or do you have any evidence or anybody from your store, or have you talked to your other people at your store about identifying this guy or having seen him here? The proof doesn't have to be long, but I think it's one of those things from a cumulative standpoint, it goes to giving more weight and more strength to the point of the argument. And without those kind of things, I think procedurally, I think it's lacking a lot that it could have had. Now, the question I would have from a lawyer standpoint is, does that proof exist, or is there any way to actually obtain it? You would think that from the store standpoint, there should be some way of getting that proof in. I mean, that seems to be the hints and the suggestions of it that you get from people like Terry Dicus and things like that, and some of that testimony. You seem to kind of think that if that stuff's there, go get it. Bring those people into court. They're subject to subpoena. Just bring them into court, get their testimony, let them say what they say, let them pull up the receipt. We write our this way. The only people that were there that day that would have written receipts are this. We go back in our employment records and see who was actually on the clock during this time frame that these people were there. We find all those records and we bring that proof in that strengthens that chain of evidence to support or refute that alibi. So the question I would have from a standpoint of the lawyering standpoint that questions it is, did the defense just miss that and not think about putting it in for some reason? Or is it possibly detrimental to their argument that this is actually is a legitimate alibi? Does it support TBI's position that the alibi is legit? But if TBI thought the alibi was legit, why didn't they bring that proof in to negate the defense side of things on the at the end of the day? It's probably just everybody dropping the ball and not doing it, state and defense, because it's an opportunity for both sides to shut that line down. If you shut down the entire line of Terry Britt being a plausible alternative narrative, then you kind of shut down a huge point of resistance from the defense.
Yeah, I mean, there was, and I'm not even going to talk about pings and cell phones and towers, because I think, well, one, because that was I was out of my depth in that, but if you set all that aside, I mean, that all the cell phone evidence that the defense tried to present to try to refute the state's case. I mean, Terry Brett, like I said, Terry Brett was a big, he was kind of the big alternative. He was my guy did not do it because that guy did. I mean, that was the line, and so, yeah, I mean, I don't know if the defense was fully effective in buttressing him up as the alternative narrative.
Yeah, I mean, we hit him fairly aggressively from a defense standpoint. They do, on the whole, a pretty capable job through the course of the testimony they presented on the defense primary case, to try to sell that as the story. But like I said, there are just big gaps in it. It's kind of the problem with on both sides of the case. There are gaps in the proof, and sometimes there's proof that should fill those gaps that we should have. Some of it's just going to be missing. There's information that we're just not going to have and never going to have.
Yeah.
The specifics of exactly what happened to Holly from the time she was abducted until the time her remains are found, you're relying almost purely on the testimony of Jason Autry, who was there even after the fact, and he's not even the full timeline of events from the time of abduction until the time she gets supposedly hauled off, wrapped up in a quilt.
Well, and again, not to kind of circle back around to Jason Autry, but just a quick aside, because I don't think we touched on this when we discussed his testimony. One of the things you and I talked about was, there was that moment, I think, where he made the quote of there was the point where he claims that he kind of entered the situation and finds out that, in fact, he's being told that Holly Bobo is dead in the back of this truck. There is a girl, there's a body of a girl in the back of the truck, and it's Holly Bobo. And he's operating at that point under the he's operating under the the notion that she's dead.
Sure.
And then there's that whole line of testimony that he gives where it's like this bitch is still alive quote that he makes.
Mm-hmm.
But one of the things that was never established, either through his testimony or through anybody else's testimony, this is one thing you and I talked about when that testimony was occurring, is what happened to her prior to her ending up in the back of that truck that would have given, if Jason Autry's story is the true story, is the actual story, and it was Dylan and Zach and Shane that had abducted her and sexually assaulted, raped her, and then they're the ones telling her she's in the back of the truck dead. We never found out the course of events that gave them reason to believe that she was dead.
Yeah.
What happened while what happened while they were in control of her through the kidnapping and the rape? That what turn of events happened that they were like, oh my gosh, she's dead.
Sure.
And that's another thing about Jason Autry's story is that, and that's what, I mean, again, maybe I'm just reading too much into it, but at the point where I have inadvertently, according to his account, I have inadvertently gotten myself into the situation of being with these people who have this dead girl in the back of their truck, and now they are trying to coerce me into helping them dispose of her body. I would think at some point I would go, what in the hell happened here?
Sure.
You know, I mean, at some point I think I would stop them and go, what did you guys do? How did you end up
with a dead girl
with a dead girl in the back of your truck?
Yeah.
And to the point, it's like, you may want my help. I'm not doing anything. We're not going any further until you explain to me what has happened.
Yeah.
And so, you know, and again, hearsay being the troubling factor that it was throughout the course of this case, those details may have existed, and there was no way to get them into testimony without violating the rules of hearsay. But I don't know. But considering how many attempts there were to get information into the testimony that violated the rules of hearsay, I you know, or maybe played a little bit fast and loose with the rules of hearsay.
Yeah.
I don't know that was the case. I feel like maybe just that info didn't exist. And did it not exist? I mean, why didn't it exist?
Yeah.
You know?
Yeah. The story that kind of goes to one of the points that the defense, I think, was trying to make with the state's pathologist on cross on the state's case about, and they did an okay job of it, I think. The defense did a pretty good job with
the whole thing about the gunshot and knowing whether or not that happened when the body,
whether it was pre-mortem or post-mortem.
Yeah,
gunshot.
Was the individual, was she alive when she was shot, or was this a gunshot? Like,
and there's no way, and there's simply no way to tell in that situation, I think, and at least the pathologist didn't think there was. And I don't know why it's part of a plausible narrative, other than the fact to say that to kind of make that relevant to her killing it all, as far as the means by which she was killed. You know, obviously, if she's already dead, the gunshot wound to the head is not going to kill her again. And then there's no direct proof specifically that Zach actually killed her at that point. Net effect is she's still dead, and she's dead at some point. And if he's tied in generally to the commission of these other felonies, the abduction, the kidnapping, and the rape, or any one of the lesser included offenses, including the facilitation, then theoretically, at least, he's guilty of the felony murder that would get him eligible for the death penalty anyway. So it's probably not a big difference from a pure legal standpoint. Go ahead.
Well, I was just going to say, you know, we've kind of gone through the vast majority of the evidence in both cases. And we've been at this for probably a couple of hours. I would say let's go ahead and wrap it up as far as let's kind of hit the high points on the closing arguments, and maybe just some final thoughts. And then also I would just say that if anybody is watching this,
there's one person at least watching.
Yeah. Hey, hi one person. How are you doing? But if anyone decides to, I mean,
it'll be up later.
It'll be up later. You can go back and watch it retrospectively. If anybody ends up watching this retrospectively, and there's something that we touched on and you want more information, if there's something we didn't touch on and you want us to kind of speak to it,
and frankly, we could have gotten it wrong,
or you feel like we've gotten it wrong, this is
one of those points that I wanted to make, kind of as we're going through these things that I didn't actually bring up, is that I am doing this now from memory of what I have heard over the last
almost 2 weeks.
2 weeks almost. And I haven't seen every piece of testimony. There have been bits and pieces, little bits. I've seen probably 90 or more % of it.
Yeah.
And I'm doing that now from recollection, and just kind of having previously kind of talked through it with you and other people during that period of time. But I think that's a reasonable way to talk about it now while the jury is currently out, which they are. They started their deliberations. It's a reasonable way to talk about this case and the thoughts you have about the case as you go, because the jury's not able to get the actual testimony back and listen to it again. If I wanted to go back and parse specific parts of the testimony again, I can go back and look at them. I can look at it, not the transcript right now, but I can go back and look at the video of witness 1, 2, 3 and go back and say, oh yeah, I either heard that wrong or I didn't remember it correctly or all that. These witnesses, these jurors are now having to review this testimony and make decisions based upon it,
Now, can't they request
they're not going to get a transcript of the trial testimony. They're not going to hear the testimony again.
Oh, okay.
They can have their notes for what they wrote down, but that's basically kind of it.
Okay. They're having to kind of largely remember it.
Correct. Which is why
closing arguments are
arguments are important, which is
leaving that lasting and final impression.
Which is why my case was significantly buttressed by the quality of their argument, and I think the defense case was significantly weakened by the quality of the argument. So I'm going to talk lawyering stuff about this, at least my lawyering perspective of it, and I think a lot of people, lay people and otherwise, probably had the same kind of perspective about the way the arguments went down. Obviously, the state goes first, and D.A. Hagerman comes on first and kind of sets out the facts. The facts that they have and the facts that they're going with, and my sweet wife is getting me eye drops because my eyes dried out and tweaky. But he sets out the facts in a very kind of calm and methodical and very even-keeled kind of way. Very significant and serious, ugly and unpleasant facts in that kind of way. He does a very good job of it. He goes through what the state's case was. He goes through the strengths of it. He goes through the points of law that he needs to go through on a lot of those things. I think his case it probably ran a little longer than he probably should have. It was like 45 minutes or so, but not terrible. Pretty reasonably compact given 2 weeks of testimony and 6 years of investigation and proof. So he finishes his first part of the state's closing.
Okay, you've given the lawyer assessment of it. I'm going to give the kind of jury box assessment for me of hearing it. It was story hour. I mean, it was very much story hour. It was his tone was appropriately grave. It was serious. It was, but it had that soft kind of flow and that kind of soft lilting flow. I remember there was a comment. There was a comment or a tweet from someone on Twitter that said, they reminded him of Jake Brigance, who is the attorney character from A Time to Kill, the John Grisham novel, and the movie that was the character that was played by Matthew McConaughey in the movie Time to Kill, which I kind of disagreed with that, but I could see it. There's there's a measure of there was calm kind of there was that calm drama. Sure. That calm drama that added, that calm drama and that gravity that he had. And I could see how that could really reach jurors. Selling the kind of the urgency of things from a listen, we know what we got to do here. We, meaning the state and the jury, this is what y'all got to do here. This is why. This is a serious and significant thing, and we've put on proof that says that these bad dudes did this thing. Specifically, this bad dude that's on trial over here. So, defense on cross is consistent with the way defense has been, which means I have no reason to think that her trial strategy and her demeanor and approach is any different. I've been, I think, reasonably critical of both sides in this case from a lawyering perspective. Equally, I think I've been pretty down the middle of the road on that. I tried to call the good stuff and the bad stuff on both sides when both sides do things that are not good, and praise them when I think they do something correctly and well. But there's not much great
that I picked up from the defense's closing. It was too damn long. It was over 2 hours. It was too long. The problem with that 2 hours wasn't that it was a compelling story in 2 hours. If it was a compelling story where you're sitting on the edge of your seat listening to every word of it and you don't know it's 2 hours, that's one thing.
But I think there was probably a definite like, oh, this is not stopping.
Yeah, and the story she needed to tell could have been told in a much more compact time. She needs to get a bunch of stuff in. She does. And it's going to take a minute to do that if you need to get that argument out. The problem with the 2 hour story that she was telling is that she was, in 2 hours of talking, she was telling a 4 hour story.
She was moving fast, and she was fast talking, and I say that as a fast talking gal myself. I mean, I can get I can get pretty wound up in a story, and and I felt, and I'm just going to kind of maybe get a little like personal with it. I kind of feel for the defense for Jennifer Thompson. I'm gonna kind of go out on a limb for Jennifer Thompson, because I've heard a lot of really harsh things said about her.
Sure.
On YouTube, or not YouTube, on Twitter, and it's that thing with the internet where it's really easy to say snarky things behind a computer. And I've made some harsh criticism, so I'm gonna own that as well. But the other thing a lot of people don't realize is that she's a private attorney. She has her own law firm. She has to make a living. She was appointed to this case because there are only, she's not a public defender in that she's not in the public defender's office. She's not in the public defender's office.
No, she is a private attorney.
What happens a lot in these rural counties is that where they don't have public, not every rural county in Tennessee has its own public defender's office. That typically only happens in larger metro areas. What happens a lot of times in rural counties is that local attorneys sign on to be
appointed counsel,
and they get paid by the state to represent basically as a public defender, but they don't work for the public defender's office. They don't work for the state of Tennessee public defender. And she falls under that category. And by virtue of the fact that this case was a death penalty case, there's only a limited number of attorneys in this state that could have taken that case, because you have to be qualified.
Capital case certified attorneys to run lead.
Yeah, only so many attorneys are qualified in this state to represent, someone who is in a death penalty case. So,
and you've got 4 defendants in this case. There's you had 4, now you've got 3. But.
Yeah, but she has had an incredible task on her. And so, and I can sympathize. I can sympathize with being nervous. I can sympathize with feeling the pressure. I feel like she probably feels like she's got someone's life in her hands.
She does.
She literally does.
Well, she does.
And I think her interaction sometimes represents that, and she doesn't, because Zach Adams is the bad guy, she doesn't get a lot of sympathy for that.
Sure.
But she, I think some of her like rambling or her fast talking or her, I think some of it comes from, she is incredible. Like I said, I know personally what it's like to get invested into something and get incredibly nervous and anxious about it and feel like it is of grave importance. And I've never represented someone who's possibly going to get the death penalty. So I have felt you know, I felt a measure of sympathy for her as the defense counsel. Now, I will say, and this is a topic that you and I've talked about, optics.
Sure. You know, I brought this up early in the trial when I saw it. There's a lot of, I mean, there's a lot of different things you can go back and look through different witnesses' testimony during the case. You look at, and I can't remember, I'm failing on his name now because it's late and it's been a minute. The TBI agent, special agent who took over after Dykus was left off of the case, the agent who comes in and falls on his sword on behalf of the TBI. Agent Booth, Brent Booth, comes in. One of the things about the optics from his standpoint, and this is going to the bigger picture of optics and the whole thing, you can tell from his carriage and demeanor, he's very, if you look at him on the stand, he's almost exclusively like facing down. He's like, you know, penitent and praying. You see there's points and significant points in the time where he's just sitting back with his hands in a peak like this, like he's praying. You know, he's penitent and begging for redemption, for grievances, and for past mistakes. Likewise, you know, witnesses are going to have all those kind of things in verbal tells. You got people that are talking with their hands going across their mouth that may say that, you know, don't believe this. There's all those kinds of things from a body language standpoint that you can make whatever interpretation you can, whether people actually see it or notice it or think about it, whether it's conscious or subconscious. From a standpoint of optics, from an attorney standpoint, there are a couple of things that are obvious. And one of the obvious things, especially from defense counsel, and I harped on it originally when I saw it sitting on the podium at about day 2, maybe day 3 of the trial. There's a big bottle of Perrier on that Attorney Thompson is using as her water source during the trial.
Hydration.
Yes. Okay, fine. It's fine to have a water bottle there. You talk a lot. Your mouth gets dry. I've got a cup over here. I've been talking a lot. My mouth's dry. Your mouth gets dry when you talk for hours at a time. I know. I talk for hours at a time all the time. It takes a lot of effort to keep up with that. From an optics standpoint, you got to think about it. And this kind of goes to one of the bigger theories and kind of one of the bigger thoughts that I've had about this case. And we've talked about this in this case, is that obviously we know Hardin County is a very rural county.
Decatur County
is even more rural than Hardin in size. It's much smaller than Hardin. Hardin's a bigger county.
And just to clarify, Decatur is where the crime occurred.
Hardin's where the
trials occurred.
So, but they're both rural. They're both small. Hardin and Savannah is a little bit bigger, not hugely bigger, but it's a fair bit bigger than Decatur County is. But nonetheless, it's still small town, very rural, Delta area, West Tennessee. You know, it's a river town. You know, there's a certain quality of folks that live there. It's not a wildly affluent, wildly upper class kind of community. It's just a standard kind of blue collar community in a lot of ways.
Plain folks,
mostly normal country folks. I don't know that they're going to see that bottle of Perrier and think, oh, well, hooty tooty snooty, all that. I think that they probably will subconsciously, though. I think it's hard to ignore something like that, especially today during closing. During closing, it's very clear that her mouth is getting dry, and that's understandable. Get a bottle of just plain, whatever plain, regular, normal bottled water is and drink from that. Perrier kind of comes across as too big city, too highfalutin, too not approachable and relatable and understandable from a standpoint.
And we're saying this as two people who grew up in in these small towns.
Yeah, but people will see things like that and think about that. They're subconscious and ticky things that you may think is nothing, but people will pick up on and run with it and say, I don't know if I can believe that big city.
Well, she's from
Nashville.
She's from she's from the Metro Nashville area, and and we made these points at in some of her either her cross examination or her direct examination, where she didn't always fully
grasp
some of the terminology that the witnesses used, and she would not really, and they would make statements or use terminology, and
sure.
And she would maybe kind of harp on it, or kind of go back on it, or not really fully grasp the meaning of it, and I think it kind of, there were points where I said, the folks on this jury, if they're from Hardin County, they know exactly what this person is saying. I mean, they're, your average, country person from, country folk from Tennessee, they know what this means. And, so I feel like there was maybe a little, that's another thing where optics and a disconnect.
It's a disconnect
that she had.
Yeah. I say, and this is something I said on Twitter earlier today too. I guess it's still today, maybe tomorrow already. But was essentially that if you have a criminal defendant that is at least kind of nominally, seriously, and wildly unlikable, his attorney really needs to be likable. Yeah. And you need to go way the other way. I mean, any criminal defendant is going to have a certain level of unlikability, but there are also certain criminal defendants.
If you can't make them like the defendant, you want to make them like the attorney.
Like the lawyer, love the lawyer, and oh my God, sit on every word you're saying. You have to have at least somebody there. You can't be not tuned in to who you are and what you are presenting as a lawyer to the jury. And I think that's one thing that Jennifer Thompson has maybe missed in this case. And it's no fault of hers. It's who she is. It's her her temperament, her demeanor, it's who she is.
And that may be entirely effective in Davidson County.
It may be, it may not be. I don't know. I mean, I would assume it probably is. There's a time and a place for things. There's a time to button up and wear the three-piece suit. There's a time to wear blue jeans and boots. And it's time. And the key is knowing which one of those times you're in and dressing accordingly. And I think she missed a lot on the closing today on that point, just from the optics standpoint. In addition, like I said, the closing today from a substance standpoint for her, for the defense, was way too long. It loses attention and loses focus, which is kind of one of the problems throughout the whole thing of the case. Now, the state wrapped up with Jennifer Nickel for the state delivering the rebuttal case on closing, and did
I have mixed emotions about that. Rebuttal.
There wasn't a lot of substance on the rebuttal that we hadn't already heard. It was almost exactly what I expected. Like I said, I expect a lot of urgency and kind of stridency and those kind of things from her in her rebuttal case, which is what she was doing. Where Hagerman went kind of methodically through the facts and why they're important and what you need to find. Nichols' point is she's going straight emotion. We're going to.
She went to the grotesque and the macabre.
There's a bit of that.
She went to. I mean, not that. I mean, don't get me wrong. Not that every part of this is not grotesque. I'm not. Please don't think that I'm saying. But I mean, she stated in clear, unabashed language.
Sure.
The single most foul and grotesque elements of what they claim, the state claims, happened to Holly Bobo.
Yes.
And that's the.
It was her story. Her rebuttal case is the emotional case. I thought, from a standpoint of her presenting it, it was probably effective. I thought that she was more restrained in the tone of the presentation. I thought it would be a little more a little more fevered, a little
I thought
more,
she was. I
a
really,
little more up tempo as far as the aggressiveness of it, which is why I said Katie barred the door when I thought that she was going to be presenting that part of the case.
Yeah, I thought she was going to come out of a bag a lot more than she really did.
She kind of kept the Hagerman line as far as flow and pacing and those kind of things.
Well,
she was much more aggressive though, content wise, and
the content was very
aggressive that way.
Yeah.
So you know, on the whole, I think it was pretty effective and is likely to be pretty effective in leaving that as the last message from the attorneys in the case to the jury. So the case, it's now sitting in the jury's hands. They had it this afternoon. Said this afternoon, as we're recording this, is Friday. It's actually now it just turned over to Friday, but it was Thursday, September 21st. They got the case at about 3 o'clock in the afternoon Central Time. They deliberated for about 3 hours, and the judge brought them back in, basically said, "Hey, are y'all still working on it?" And they said yes, and he gave them the break for the rest of the evening since it had already been a long day. And they're going to come back in the morning, resume their deliberations.
Yeah.
So they had an original jury pool of 15 sitting there, so that they had some alternates in case anybody needed to get out. They culled that down after the closing, before the final instructions, down to the 12 that are actually going to deliberate to verdict, assuming it gets to verdict.
Yeah.
So now it's kind of a waiting game on the case. We're really just waiting on verdict from the jury to come back, and whatever that might be. I think I've been pretty consistently of the opinion that I have not given one on what I think the verdict would be. I don't know. I still don't know.
I really don't know. I will say, God bless these jurors, because
it is.
I do not envy the task before them, because
it is a difficult case, both on the substance of what the case is about, and it is a difficult case from a standpoint of what was given to them to consider. I mean, they're putting in a balance between knowing that this horrible, terrible thing happened, and here's the person that the state's saying did it, and here's the story they're saying did it, but did they give us enough to actually do this, to actually convict this guy of this crime?
And I think for me, I've kind of, I know as far as like things that I've posted on Twitter, and I've kind of been criticized by some people thinking that I'm a apologist for Zach Adams. I'm not. I don't know whether or not he's guilty or innocent. I'm trying not to form an opinion that way. Mine, and I know you, but you especially, as someone who makes your living in the judicial system. But me, I want to know that if they convict him, if the jury comes back and delivers a guilty verdict, I want to know that it is because the state met the highest. They met their burden of proof. They met their burden of proof to the highest degree. Because, and this speaks to a Twitter comment that I saw that somebody kind of made randomly, that was like, so when's the Netflix documentary about the Holly Bobo case? Sure. And I think that's a good point to make. This is the time, that's kind of a function of the time we live in. We've got podcasts. I mean, you've got the two of us sitting here doing this, and you've got podcasts that make a living now on evaluating, either true crime, cold and or closed cases. And there are a lot of cases that, 5, 10, 15 years later, have been reevaluated, and whether it's because of a Netflix documentary or it's because a handful of celebrities have gotten behind their cause, you know, it has called that, you know, it's called these convictions into question. It's called this judicial process into question. And so I mean, my point is that if Zach Adams is convicted on all of these charges, I want to know that it is because the state of Tennessee and our judicial system met their burden. Sure. They did their job. They were, you know, they met and they exceeded what they had to do. Because the thing is that we do have someone, this is someone's life, you know, and, you know, and a lot of people argue, well, he took a life. So we don't, I mean, if there's a chance that he didn't, we have someone's life in our hands, whether that is figuratively by virtue of the fact that he may spend the rest of his days on earth in a prison cell, or that's literally because the state of Tennessee is going to put a needle in his arm and take him and kill him. You know, there's somebody's life at stake. And I think that, you know, the state is the only entity that has the ability to do that legally. Yeah. And so they need to be held to this high standard. And I just don't want to see that, you know, 5, 10, 15 years from now, there's, like I said, there's the Netflix documentary, there's the podcast, or there's a handful of celebrities that get behind his name, and now our judicial system is being called to question.
Yeah. Yeah. I mean, for me, on the whole, in this particular case, I think there's a probably better than likely chance that the case went down more or less the way the state has presented it. I think there's probably a decent to better than average likelihood that Zach Adams is guilty, in addition to all those other folks with him. In that case, my vote in the jury room would have to be not guilty in that case, if all I can say is better than average, more than likely. Now, there are different shades of where you fall in that scale. Now, beyond a reasonable doubt is way over here. Everything else is below that. Everything else below beyond a reasonable doubt is not guilty. So you have to keep that in mind. I'm not saying that he's not guilty of the crime. I'm saying that legally speaking, maybe that's where.
Do we know? Are we fully convinced that the state met their burden?
Yeah,
are we fully convinced that they?
And I think that's the situation here. And before, and I say this to everybody in thinking about this, and it's a consideration that I think everybody should make. Imagine it was you sitting in the criminal defendant's chair on trial, especially on trial for your life, accused of a murder that you did not commit, that you were wrongfully accused of. You're on trial for your life. What burden and what burden of proof would you want the state to have to live up to? What process, what procedure would you want sitting in that chair to try to save your own life? Now, you should afford that to anyone that's in that spot, even the most heinous and vile that are done that way, because you want that. It's the same way you should defend vile and heinous speech, because you want to protect your speech from being accused of being heinous and vile, maybe correctly, maybe incorrectly, but you want to protect those things. It's not that we're saying that he should walk, he should be free. Maybe,
or that he's innocent.
Or that he's absolutely innocent. But he deserves a full process and a fair, impartial hearing and a judgment, a verdict rendered by a jury of his peers in this situation. That's what I think the process is designed to do. That's the process of justice. Justice is the process where we work through a system of law and a process and procedure, and we follow those things, and we follow those laws, and we follow those procedures to ensure equal and fair treatment to come to a result that is as just as we can accomplish. People are imperfect. They're going to make good decisions. They're going to make bad decisions. All kinds of people every day are going to make those. Juries, criminal defendants, lawyers, they're all going to make those kind of decisions, some good, some bad. They're going to have different consequences. But you have to follow the process. If you follow the process and stay within the confines of that, and do those things that way, then the result is a just result, whether it is a conviction, whether it's an acquittal, or whether it's a hung jury or anything in between. guilty on something, not guilty on something. Probably not likely in this case. It's probably guilty on all or not guilty on all.
I mean, it turns my stomach to think that if he's guilty, he could possibly walk.
Sure.
Because the state didn't do an adequate job.
Mm-hmm.
But it equally turns my stomach if he's innocent, and he goes to prison or for the rest of his life and or receives a death penalty. I mean, neither one of those are, what I really hope is that I hope that they found the right guy and they have the right proof.
Yeah.
They presented the right proof. Do we know if that happened? I don't know. But so I guess that's.
But we're waiting on a jury, and we'll still be waiting on a jury for some period of time. They're presumably not going to make a decision first thing tomorrow morning on Friday.
Probably not.
My initial estimation and guess, and this was just a wild guess because I don't know, was that I expected the jury will be back midday sometime, probably Saturday. That gives them an approachable, reasonable amount of time to try to condense all this stuff down and come to a conclusion. Because supposedly, I mean, if the jury is acting in the way they've been instructed, they shouldn't have been talking about this case or considering it with anybody else on the jury until 3 hours, or for the 3 hours today is the first time they've actually talked about it with any of their peers on the panel. So they've only had 3 hours to go through anything. Whether they've even had a vote yet about the thing, I don't know. I assume they've elected somebody as their foreperson, and that they're going to commence and resume their their deliberations bright and early on Friday morning. So anyway, I appreciate anybody that actually watches this. I appreciate my lovely wife for coming along and encouraging doing this. You have anything to say in reference?
I mean, I've enjoyed it. It's been nice to kind of talk it out. We've kind of been, living room talking it out for the past,
2 weeks.
2 weeks. And, if anybody, thanks one viewer, but if anybody else ends up looking at this and you have questions, if you want us to speak to anything else, if you have thoughts, feel free to tweet us. I am at Tooth Criminal.
I'm at JAYL Johnson. And if you're in need of legal services, you can feel free to give me a call if you're in Tennessee. But I'd be happy to talk to you about that. Maybe not your death penalty defense, but we'll talk about other stuff if you need it. Anyway, thanks for watching. And we may or may not be back, but we'll try it again in the future maybe. Talk to you later.
All right. Bye.